Good afternoon, everyone. My name is Felix Hone. I'm Assistant Professor here at the College of Law, and I'm pleased to welcome you to the 2019 Law Foundation of Saskatchewan lecture, Discarding Old Prejudices, Judicial Precedent and Aboriginal Title, presented by Professor Kent McNeil, the Law Foundation of Saskatchewan H. Robert Arscott Chair. As we gather here today, we acknowledge we are on Treaty 6 territory and the homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. This event is presented as part of the McKercher LLP lecture series at the College of Law, and so I would first of all like to thank McKercher LLP for sponsoring this lecture and the lecture series over the last 4 years, allowing the college to continue to present a wide variety of informative, educational, and entertaining speakers to the law school community. Professor McNeil is serving as the Law Foundation of Saskatchewan H. Robert Arscott Chair from July to December of this year. In addition to teaching a course on comparative Indigenous rights, he has organized a workshop on Indigenous voice, cultural appropriation, and the place of non-Indigenous academics. He's also doing research on Indigenous rights in Canada and Australia, and he is co-editing a collection of leading Canadian Indigenous rights cases. Professor McNeil is a graduate of this university with both a Bachelor of Arts in History and a Bachelor of Law from this college. After law school, he articled with the Attorney General's Office, Department in Regina, and he was called to the Saskatchewan Bar in 1980. From 1980 to 1982, he worked at the Native Law Center, first as a research associate and then as the director of research. His interest in Indigenous rights took him from there to Oxford, where he completed a Doctor of Philosophy. His dissertation was published in 1989 as Common Law Aboriginal Title. The timing of this book was fortuitous, since the Mabo case was being litigated in Australia at that time, and it's obvious from the Australian High Court's many citations of Professor McNeil's book that it helped persuade the High Court to acknowledge the common law existence of Indigenous land rights for the first time in Australia's history. His book has also been relied upon by the Supreme Court of Canada on many occasions in cases relating to Aboriginal title. After leaving Oxford, Professor McNeil began his teaching career at Osgoode Hall Law School in Toronto, where he became a distinguished research professor in 2007. Now, I could easily go on with a long list of accomplishments and honors, but I know Professor McNeil doesn't want me to do that. So I will just conclude by mentioning that if you haven't already picked up a copy of his most recent book, entitled Flawed Precedent, the St. Catherine's Case in Aboriginal Title, published by UBC Press, I'm sure you will want to do that after this lecture. Professor McNeil has published on many aspects of Aboriginal law in Canada, and courts and scholars have repeatedly relied upon those works and have benefited greatly from his depth of knowledge and insight. Please join me in welcoming Professor McNeil.
Well, thank you, Professor Hone, for that very generous and kind introduction. I would like to start by acknowledging that we are on the lands and territory of the Treaty 6 peoples, and that this is part of the homeland of the Métis Nation. I'd also like to thank the McKercher law firm for sponsoring this lecture series, and also the Law Foundation of Saskatchewan for making it possible for me to spend a few wonderful months here at the College of Law in Saskatoon. I'm thoroughly enjoying being back in the city, where I spent several years going to school and working at the Native Law Center. And despite the cold weather and the snow today, and I have been reconnecting with old friends and, of course, making new friends here in the city. I'd also like to thank Dean Martin Phillipson and the staff of the college for being so supportive and welcoming to me. It's been wonderful. Also, I'd like to thank the Native Law Center and Director Marilyn Poitras. They've been providing me with a lovely office and a very congenial space in which to work, so I thank them as well. My talk today is going to be a combination of legal history and current law. The legal history is important because it informs the current law. It also reveals, in this case at least, it reveals that I'm going to be talking about, it reveals the racism in Canadian law that retarded the development of the concept of Aboriginal title for many, many years, right up till the 1970s, really. So my focus on the early law is going to be on the St. Catharines Lumber and Milling Company case that was decided in Ontario in the 1880s, and it went all the way to the Privy Council in London. And it became the leading judicial precedent on both the source and the content of Aboriginal title in Canada, right up until the 1970s when the Supreme Court started to question it in the Calder decision, which was decided in 1973. The question in the St. Catharines case was this: did the Crown in right of Ontario or the Crown in right of Canada benefit from the surrender of Indian land rights by treaty? And the treaty involved there was Treaty 3, the northwestern part of Ontario around the Lake of the Woods, which was entered into with Canada and the Saulteaux people of the Anishinaabe in that area of Canada. Treaty 3 covers a large area, 55,000 square miles, which is about half the area of Italy, just to give you an idea. The Privy Council decided that the surrender of Aboriginal title benefited Ontario rather than the Crown in right of Ontario, Crown in right of Canada. And the reason was that the province, the court said, had the underlying title to Aboriginal title lands due to Section 109 of the original BNA Act, or now the Constitution Act 1867. And the reason for that is that that provision says that the original 4 provinces in Canada, Ontario, Quebec, Nova Scotia, New Brunswick, retained most of the public lands. There are some exceptions, but most of the public lands were retained by the provinces when they got together and confederated in 1867. That aspect of the ruling has never been questioned, and I don't plan to question it today. That is that it's the provincial crowns that have the underlying title to Aboriginal lands. What I do want to talk about is what the Privy Council had to say about both the sources and the content of Aboriginal title. Lord Watson, who wrote the judgment for the Privy Council, said that Aboriginal title is, and I'm quoting, a personal and usufructory right dependent upon the goodwill of the sovereign. End quote. And then he also said that the Crown has the underlying title to Aboriginal title lands, and that the Crown's underlying interest is substantial and paramount, that it's a property interest that's substantial and paramount, and that the Aboriginal title is a mere burden on the Crown's underlying title. Lord Watson apparently thought that the Crown got the underlying title as a result of the cession of French Canada from France to Britain by the Treaty of Paris in 1763. Shortly after that treaty, King George III issued the Royal Proclamation of 1763 to protect Indigenous lands in North America from unscrupulous settlers. And Lord Watson said that the Saulteaux' possession of their lands, quote, such as it was, and that's a very important phrase, their possession such as it was could only be attributed to the Royal Proclamation. So the Royal Proclamation for him was really the source of Aboriginal land rights. His description of Aboriginal title as a personal and usufructuary right was based entirely on the Privy Council's interpretation of the Royal Proclamation. And that interpretation governed the understanding of Aboriginal title in Canada right up to the Calder case in 1973, when the Supreme Court finally began to question it. Lord Watson's description was subsequently rejected by the Supreme Court in the Dalgamook decision in 1997. And then in the court's more recent decision in Silcotin Nation in 2014, the court affirmed that Aboriginal title amounts to the entire beneficial interest in the land. It's not just a personal and usufructuary right, it's the entire beneficial interest in the land, and that includes both the surface and the subsurface. And it's not restricted to traditional uses. They can put the land to any use they wish, subject to a limit that don't have time to go into right now. But basically, Aboriginal title is very much like a fee simple. It's inalienable, however, except by surrender to the Crown. Well, what about the Crown's underlying title? Well, in the Silcotin decision, the Supreme Court made clear that the Crown's underlying title has no beneficial content whatever. You know, my understanding of it would be that it's very much like the Crown's underlying title to fee simple estates. So it would give the Crown something like a right to escheat, but no beneficial, there's no beneficial content to the Crown's underlying title. Well, given that the characterization of Aboriginal title in the St. Catharines case has been rejected by the Supreme Court, you might well ask why it's worthwhile to still talk about that aspect of the case today. Well, I think there are two reasons for this. One is I think that legal history is important because it helps us today understand the current law and where that law came from. But there's a second reason, in this context at least, that I think is even more important. Over the past few years, a debate has been developing over whether Aboriginal title amounted to a legal right or amounts to a legal right enforceable against the Crown back in the 19th century. You know, some people have been arguing that it only became a legal right in the modern case law, starting with Calder and the more recent decisions like Dalgamook and Silcotin Nation. You know, on the other side of this debate are people like myself and my colleague Brian Slattery and Mark Walters, and we all would argue that Aboriginal title has been a legal right in the common law ever since the colonization of Canada. But on the other side, you know, the argument is that no, it wasn't legally enforceable. It was just based on political, moral grounds, and that the Crown had complete discretion in dealing with Aboriginal title lands. It was not bound in any way by law. And this academic debate has surfaced in recent cases in Canada. For example, in the Ross River Dene case from the Yukon, which was decided at trial in 2017, and then in the Restool versus Canada case from Ontario, which was just decided less than a year ago in December 2018. And in those cases, the federal Crown was arguing that the Indigenous peoples had no legal rights to their lands in the 19th century. So this argument, was being used in current court cases. The Restuel case is still ongoing. In fact, I know the second stage of the trial was just taking place, being argued, maybe evidence presented last week, and it may still be ongoing. And that case involves a term in the Robinson-Huron and Robinson-Superior treaties, both of which were entered into in 1850. And the provision, the term that I'm talking about, provides for annuities in the treaties to be increased if the resource revenue from the land increases. And these are lands, north of Lake Superior, north and east of Lake Huron, and it's mainly, forest and lakes and rivers and so on. But there's a lot of mineral wealth and also forestry wealth in the areas of those two treaties. Well, there were small increases in the annuity payments. I think the last increase was in 1875. And the current annuity is $4 a year per person, with nothing built in there respecting inflation. So the trial judgment, as I say, which came down just in December of last year, Justice Hennessy decided that the annuities should have been increased. I mean, billions of dollars in resource revenues have been taken out of these lands with no increase in the annuities. The second phase of the trial, I think what it's about is determining how much the annuities should be increased. Because the first trial, Justice Hennessy said, yes, they should be increased, go back and negotiate and come to a reasonable settlement on this, but they weren't able to do that. So now it's the second phase is actually taking place. But one argument the Crown was originally using to counter the claim that there was a legal right to increase the annuities, one argument that the Crown apparently was using was that there was no legal right to the land, that the Indigenous parties to the treaties had no legal rights to the land at the time of the treaties. And I think the Crown thought that that would strengthen their argument that there was no legal right to increase the annuities. So you see, this is not merely a matter of legal history. The current rights of Indigenous peoples in Canada can depend on whether they had enforceable rights back in the 19th century. So I'm going to come back now to the St. Catharines case, decided by the Privy Council in 1888. So what caused Lord Watson to conclude that the Saulteaux's possession, remember, such as it was, could only be attributed to the Royal Proclamation of 1763? And the answer, I think, is that there was no evidence whatsoever to support any other source of Aboriginal land rights. In other words, what was lacking in the St. Catharines case was not law that would support these rights, but evidence, facts that would support them and allow that law to be applied. Well, what kind of facts? First of all, facts demonstrating that the Saulteaux's occupation and use of the land amounted to possession. If they had factual possession, then the common law presumption is that they should have had title, because in the common law, title is presumed from possession of land. And Justice Emmett Hall, in the Calder case, actually decided that. He found that the Nisga'a had title to their land because they had been in possession of it at the time of Crown assertion of sovereignty. And possession in that case had actually been admitted by the Crown. That's never happened since, as far as I know. In Delgamuukw and the Silcoteen Nation, there was, in both cases, very long trials, and most of it was about evidence, introducing evidence of Indigenous occupation of land, but also of Indigenous law, and I'm going to come back to that. So if evidence of Indigenous land use had been and occupation had been introduced, then I think that there was at least a chance that the Privy Council would have decided this case differently. But the political, ideological, and historical context in the 1880s was very much against the Indigenous peoples as well. And I think that those factors had a major impact in this case. So let me just mention a few of these factors. First of all, racist theories based on social evolution, theories of social evolution, were dominant in the 1880s. So-called armchair anthropologists, most of whom had little or no direct experience with Indigenous societies, speculated that human societies progressed from a bottom level or range, which they usually called savage, up through barbaric, up to civilized. And there were sometimes other sort of grades put in those, in between those. And of course, Indigenous peoples in North America were regarded towards the bottom in the savage range, and who was at the top? Well, of course, Europeans, right? So that was one thing that was happening, and in the St. Catherine's case, if you read the trial judgment of Chancellor Boyd, and I'd recommend you reading it sometime, because it's full of racist language that reflects these theories of social evolution. And he found that and excuse me for the language here, but this is the kind of language that's used in the judgment, that, you know, those people were primitive, they were wild, they wandered over the land, they had no fixed abodes, no real attachment to the land, so no possession of it, right? And what's remarkable about all this is there was no evidence whatsoever for these conclusions. The Saulteaux were not parties to the case. No Saulteaux were called as witnesses, and I'm sure they were not even aware that this case was taking place. The sole witness in the case, there was only one witness, it was Alexander Morris, who was the chief negotiator for the federal government of Treaty 3. And the transcript of his evidence is less than 2 pages long. And really all he testified to was the fact that, yes, the treaty had been negotiated and entered into in 1873. Other than that, all the evidence was documentary, and most of it was on the historical relationships between the Crown and the Indigenous peoples. There was virtually no evidence of Saulteaux society or of their relationship with the land, and there was no evidence whatsoever of Saulteaux law. So without evidence, how did Chancellor Boyd arrive at his conclusion that they were primitive savages who were, and excuse this language, but I'm quoting here, more degraded than the usual Indian type, end quote. That was his assessment of the Saulteaux with no evidence whatsoever. Well, I think that assessment of his came from the prejudiced assumptions based on racist attitudes that were all too prevalent in Anglo-Canadian society in the 1880s. So that's sort of the ideological context. Regarding the historical context, the 1880s were a terrible decade for the Indigenous peoples in North America. In 1887 in the United States, Congress enacted the Allotment Act, which was designed to break up tribal communal holdings, the reservations, into individual property holdings. And as a result of it, the Indian nations in the United States lost about 2/3 of their land. This privatization of their land led to great losses in terms of land. In Canada, this is the decade when the potlatch and Sundance were outlawed by legislation, by Parliament, amendments to the Indian Act. It's also the decade when the residential schools were introduced systematically in Canada. There were some before this, but I think in the 1880s, residential schools became the policy. There are also amendments to the Indian Act that allowed imposition of the band council system to replace traditional forms of government. All that was happening in the 1880s. It's also worth noting that at the very moment the St. Catharines case was being litigated, during the trial, it was the exact time when the Riel resistance was taking place here at Batoche, close to Saskatoon. And in fact, two of Chancellor Boyd's sons were in the army and had come out west to fight against the Métis and the Cree who had joined that resistance. All of the lawyers and Chancellor Boyd himself, I think, contributed to Canada's war effort to put down what they regarded as an uprising. So, that's the decade when this case was being litigated. And the unfortunate thing is that Chancellor Boyd's factual findings about the nature of Saulteaux society and their relationship with the land and so on, those became the facts that supported the trial or the judgments on appeal, first to the Ontario Court of Appeal, then to the Supreme Court, and then to the Privy Council. So the Privy Councillors, or the Lord of the Privy Council, are sitting in far off London, and this is the only evidence they're going to have relating to Saulteaux occupation of the land. So no wonder Lord Watson concluded that the Saulteaux possession of the land, such as it was, could only be attributed to the royal proclamation. I think if evidence of Saulteaux land use and law had been available to the Privy Council, the outcome could have been very different. And there is evidence for this, or support for this, in 3 Privy Council decisions decided shortly after the St. Catharines case. So the 3 cases are Naria Tamaki, which was a New Zealand appeal in 1901, so only 13 years after St. Catharines. The second one is Re Southern Rhodesia, decided by the Privy Council in 1919. And the third one is Amodu Tijani, decided by the Privy Council in 1921. And in the first of these 2 cases, the Privy Council held that if evidence of customary land rights were to be presented to the courts, those land rights would be enforceable, whether it was the Maori in New Zealand or the African peoples of Southern Rhodesia or of Nigeria. In each of these cases, they could rely on their customary rights and under their own laws. And in the Amodu Tijani case in 1921, the Privy Council did in fact enforce land rights as against the Crown based on the customary law of the Nigerians. So, from these cases, it's obvious that one possible source of Indigenous land rights is Indigenous law. A second potential source is possession of land and the common law rule that possession gives rise to title. And as I already mentioned, that was one of Justice Hall's conclusions in the Calder case. And he dissented in that case on the issues of Crown immunity and extinguishment. I don't have time to go into those, but he dissented on those issues, but not on the issue of the source of Aboriginal title, because Justice Judson, who wrote a judgment for himself and two other judges in the case, also said that Aboriginal title in British Columbia does not depend on the Royal Proclamation of 1763, but it arises from the fact that Indigenous people were here occupying the land as organized societies at the time the Europeans arrived. So actually 6 out of the 7 judges in the Calder case in 1973 agreed that Aboriginal title is a legal right to the land. And then in Delgamuukw in 1997, Chief Justice Lemaire affirmed that there are 2 possible sources of Aboriginal title apart from the Royal Proclamation. You know, the court's no longer relying on the Royal Proclamation as the source. So again, those 2 sources are Indigenous law and the common law rule that title is grounded in possession. This was not new law in 1973 or 1997 when these cases were argued, or decided rather. The Indigenous law source, as I said, was affirmed by those Privy Council decisions from New Zealand and Africa. And the common law source simply applies the principle that goes way back in the common law, all the way to the possessory assizes in the late Middle Ages, and the real actions, which were based on possession. You know, that's a fundamental part of our common law. Application of the principle that possession gives rise to title can be found in numerous adverse possession cases from the 19th century and earlier. So not to apply this principle to Indigenous peoples and to say that their occupation of the land did not amount to possession would be unjustified and, in my opinion, highly discriminatory. And I think that is what the Supreme Court began to realize in Calder and Delgamuukw, and more recently in Silcotin Nation in 2014. But what made this possible was the factual record. You know, I said in Calder, possession by the Nisga'a was admitted by the Crown. In Delgamuukw and Silcotin Nation, there was extensive evidence of the possession by the Gitxsan, Wet'suwet'en, and Silcotin Nations of the territories, of the lands that they were claiming in those cases. So to sum up to this point, the main argument I want to make, or the main point so far, is that there was ample law at the time the St. Catherine's case was decided in the 1880s for Aboriginal title to be found as a legal right, either on the basis of Indigenous law or on the basis of the common law rule that possession gives rise to title. But to apply that law, the courts need evidence. And that was entirely lacking in the St. Catherine's case. So when evidence of Indigenous occupation and law was presented in the more recent cases, that gave the Supreme Court the means of applying the law and applying the Indigenous law on the one hand, or applying the common law rule on the other hand. So in the Delgamuukw case, for example, Chief Justice Lemaire identified these 2 sources, and then he went on to say that Aboriginal title is proven by evidence of exclusive occupation of land at the time of Crown assertion of sovereignty. So this exclusive occupation is what, according to the Supreme Court, gives rise to Aboriginal title. And then Chief Justice Lemaire and Dalgamook defined that as an exclusive right to possession and use of the land that's not limited to traditional uses and that includes both surface and subsurface rights. So this Aboriginal title is what my colleague Brian Slattery calls a generic right. It doesn't vary from one Indigenous nation to another. So it would be the same across Canada. You have exclusive occupation, you prove that at the time of Crown assertion of sovereignty, then the Indigenous people in question would have this title as defined by the Supreme Court. So from this, it appears that the source of Aboriginal title that the Supreme Court is relying on is the common law rule that title arises from possession. If the second source, Indigenous law, was being relied on, then one would expect the definition of Aboriginal title to change from one Indigenous nation to another, because we know that Indigenous law across Canada varies greatly from one region and one nation to another, depending on a variety of factors, cultural differences, differing uses of the land, and things like climate and geography and so on. So what then is the role of Indigenous law in relation to Aboriginal title? It seems from Dalgamook, and you see the same thing in Silcote Nation, the court is just relying on exclusive occupation at the time of Crown's assertion of sovereignty. Well, I think the role of Indigenous law in this context is really twofold. First, it can be part of the evidence that's used to establish exclusive occupation. And Chief Justice Lemaire says this in Dalgamook. He makes it clear that if the Indigenous people in question had trespass laws or land use laws or land tenure laws, that this would all be part of the evidence that they could use to prove their exclusive occupation. And that's what's necessary to give rise to Aboriginal title in the common law. But is that the only use of Indigenous law in this context? If it is, then it would seem that Indigenous law is not a source of Aboriginal title. It's only part of the evidence that can be used to establish it under the common law. And yet, Chief Justice Lemaire in Dalgamook referred to another case, Roberts versus Canada, not a very well-known case in Indigenous rights jurisprudence, but this was a 1989 decision where a unanimous Supreme Court held that, and here I'm quoting, Aboriginal title predated colonization and survived British claims of sovereignty, end quote. Predated colonization. But if Aboriginal title predated Crown sovereignty, then Aboriginal title cannot have arisen solely from exclusive occupation at the time of Crown assertion of sovereignty. To be a pre-existing right, it must have arisen under pre-existing Indigenous law prior to Crown sovereignty. So referring to the Roberts case, Chief Justice Lemaire said this. He said it, quote again, suggests a second source of Aboriginal title, the relationship between common law and pre-existing systems of Aboriginal law. So we've seen that Aboriginal or Indigenous law doesn't define the content of Aboriginal title. So in what way is it a source of Aboriginal title? Well, for me, and this is my own interpretation, it's not what the court has said, but for me, the only way to understand this is to distinguish between the external and the internal dimensions of Aboriginal title. So my understanding is that the common law and the rule that possession gives rise to title, they define Aboriginal title externally, as against the Crown, as against the outside world. So this is the external dimension of Aboriginal title. Internally, and that is within the Indigenous nation's own territory, Indigenous law applies to define the rights of the members of that nation among themselves. So when the British Crown asserted sovereignty over the Gitxsan, Wet'suwet'en, and Silcotin peoples, and the court accepted that that happened in 1846, the Crown, in fact, exercised no authority over those territories. You know, the only Europeans who'd visited there were fur traders and an occasional missionary. There was no governmental presence in the territories of these peoples in 1846. So English law could not have applied there. And the only law that could have governed the land rights of these peoples internally was their own legal systems. And those legal systems must have continued after 1846. I do not understand how it could be otherwise. So Indigenous law must therefore continue, and I would argue continue to this day, to define Aboriginal title internally within the nations that hold that title. So common law, just to conclude, so the common law and Indigenous law are both sources of Indigenous title in this sense. The common law applies externally as the source as against the outside world, and Indigenous law applies internally as the source of Aboriginal title rights among the holders of those rights. So I'm going to end there. Thank you very much for your kind attention, and I think we've got some time for questions, so I'd be happy to try to answer any questions you might have. Yes?